Going to try to set this for a preliminary examination?
Discovery is complete,
Yes.
and would the people have their witnesses available the 5th?
Judge, I'm not available the 5th, so I was going to ask for the 19th.
Yeah. What happens to people when they ask for dates? Mr. Bellinger? Never mind.
He has a sense of humor.
Will that be acceptable to the people? The 19th. Preliminary examination will be set November 19th, 2024, 9 a.m. That is before Judge.
Buckle up, guys. Today we're stepping into a real courtroom moment where tension hides behind formality. The judge begins setting the date for a preliminary hearing, and everything seems calm, almost routine. But as soon as scheduling conflicts arise, the judge's tone shifts. You can already sense the undercurrent of strict authority that's about to define the entire hearing. The energy is formal, yet thick with expectation. What seems like a simple scheduling talk will soon turn into a serious confrontation. The calm before the storm has just begun.
Judge Barr.
There are some issues regarding bond that I do hope to address with the court.
Yes.
And I was made aware of them earlier today, Judge, just so you're aware.
It's come to my attention, Your Honor, that the defendant has, in my opinion...
The calm breaks fast. The prosecutor takes the floor, pointing out possible violations of a no-contact order. Her tone is serious, measured, but firm. It's clear she believes the defendant has crossed a line. This is where the courtroom energy changes. You can feel eyes shift toward the defense, waiting to see how they'll justify what's about to sound like direct defiance of court rules. The tension builds, and the judge leans forward, ready to listen. You can almost sense everyone bracing for what's coming next. The courtroom is officially on edge.
And violating the no-contact order, I understand the court might perceive it as towing the line. However, he has sent a package with a note to the victim's residence. It's my understanding.
Things heat up when the prosecutor reveals what happened. A package sent to the victim's home with a note that says, "I love you all so much." Add to that, the defendant was seen driving near the soccer field where the victim was present. Each detail sounds innocent on its own, but together they paint a pattern of boundary-pushing behavior that immediately raises the judge's suspicion. The defense seems unprepared for how specific these details are. Every revelation lands heavier than the last. By now, the entire courtroom is hanging on every word.
That the defendant characterized this as sending it to the kids. However, the note in it said, "I love you all so much. Love someone who loves you more than you could possibly know," or something along those lines. And then there's the additional incident of the defendant at least once being seen driving past the soccer fields while the child in common was in practice after, I believe the court explicitly stated that he was not to be at.
The defendant tries to defend himself, saying he only sent blankets for his kids, not to contact the victim. His tone is calm, but nervous. The defense insists it was a simple act of love for his children, not a violation. Yet, as the timeline of events unfolds, the courtroom feels skeptical. Every word from him seems to tighten the air, setting up for what's coming next. The judge's expression remains unreadable, but the silence in the room says it all. This is where small mistakes start turning into big consequences. The courtroom feels colder now.
Events while the victim was present. So I am concerned at this point. This does seem to be, in my opinion, multiple violations of the no contact order, and I wanted to raise it.
Judge, he did send a package to his kids, which was just blankets for his kids, and a note directed to his kids. Granted, the package was addressed to the complaining witness, but...
Excuse me?
The package was addressed to the complaining witness, but it was just for the kids. He sent blankets to the kids. And then as to the...
When was that?
Now the judge starts pressing harder. He asks, why was the package addressed to the victim if it was for the kids? The defendant stumbles, admitting he didn't think about that part. The children's ages come up, 7, 8, and 9. and the judge's patience thins. His sharp tone makes it clear. This isn't about feelings anymore. It's about obeying orders without bending the rules. You can see the defendant trying to hold his ground, but it's not working. The judge's body language says frustration. Every pause feels like judgment. The pressure is undeniable.
Your Honor, it was ordered, I believe, on the 19th, but I do also want to put on the record that the victim moved and the defendant had to go to great lengths to find out where they relocated to. So that is another reason. Sorry. She did not share her new location with the defendant. She did not want him to know where she lived.
The 19th, you said?
Let me confirm one moment, Your Honor.
When Judge Simpson sits back in that chair, it's not a good thing for people that may not know him.
Ordered October 16th.
What was ordered October?
That was when the package was ordered.
Gotcha. How old is the child?
As the judge digs deeper, the defendant explains how he found the victim's new address by logging into a utility account. It sounds like a loophole, and that's exactly how the judge sees it. What was supposed to sound innocent suddenly sounds calculated. The courtroom falls quiet. You can feel the judge's disbelief growing as the defendant unknowingly strengthens the case against himself. The air thickens as the prosecutor watches in silence. Each explanation feels like another nail in the coffin. The balance of sympathy is quickly fading.
There's 3 children, Judge. How old are your kids?
7, 8, and 9.
7, 8, and 9.
So, why was the package addressed to, well, a couple things. What was the purpose of this?
To send something to my kids because I'm not able to contact them. And it's just something I knew that they would enjoy.
Then comes the turning point. The judge zeroes in on a simple question. Why 4 blankets when you have 3 kids? The silence after that question is deafening. The defendant fumbles for an answer, saying one was just an extra blanket. But the judge doesn't buy it. That single inconsistency becomes symbolic. It's the moment the judge loses faith in the story entirely. The tension now feels almost physical. The defendant's voice shakes slightly. You can sense everyone realizing that trust in his words has completely slipped away.
So,
I was told that I wasn't able to contact her, and I was trying to abide by that and just send it to my kids. I addressed it to her, not...
why did you address it to her?
It was just something that crossed my mind because it came up as that address. I didn't mean to address
What do you
it to
mean
her.
if it came? I don't know what that means.
I didn't mean to address it to her. I meant to address it to them. I just didn't think of that part of it.
Excuse me?
That makes no sense.
I was trying to
You
send my
meant to address it,
to my children.
Corporal.
Uh-oh.
You what?
He meant to send the package to his children.
So why weren't their names on the pack?
Because it was meant as a surprise, because they all had different blankets that they enjoy, and I couldn't leave it blank.
He could have just addressed it to the kids. It still would have been a surprise.
I was just trying to send something to my kids. I wasn't trying to disobey any rules, and this is all new to me. I haven't done this before, and I was just trying.
The courtroom tension peaks. The judge leans in, practically dissecting every word. The defendant insists his story is true, while his attorney scrambles to explain the alleged soccer field sighting. The judge's expression says it all. He's not convinced. What began as a bond discussion now feels like a slow-motion collapse, as each defense explanation only makes things worse. The silence between exchanges grows longer. Every word from the judge hits harder than the last. The case feels like it's spiraling toward a decision no one can stop.
Trying to send something to my kids.
Okay. How'd you find their address?
So when I was able to move back into my house, the power was off. So we have a list of accounts that we have at our house. And so I got onto DTE to turn it back on. And that's when I saw her address because the account was used. She used the same account. So I paid that off. And then it was said that I had to create my own account. So I logged off and created my own account. But her address was on there when I logged in. So I paid that bill and then logged off and created my own account.
So prior to doing that, you didn't know where your kids were.
I did not. I didn't do it to find them. I had to turn the power back on my house and I went to where I knew I had to go.
And so once you see that,
Yes,
then you decide to send the package?
to my kids, yes.
But Your Honor, there
The judge's patience runs out. He questions the defense and warns that is about to revoke the bond. You can almost see the defendant realize the gravity of the situation. The lawyers start negotiating hearing dates, trying to buy time. But the judge's tone says it's too late. His mind is nearly made up. The shift from dialogue to decision happens fast. Even the defense seems to sense defeat. The courtroom atmosphere turns heavy, as though everyone knows what's about to happen next.
were 4 blankets sent and he had 3 kids. So I don't really understand how that's going.
Oh, he in the chair. 4 blankets, 3 kids. 1 was for the lady.
All right, I'll ask the $1 million question. You have 3 kids, you're sending them a blanket. Why'd you send 4? Please, you know what?
I don't.
Think about your answer to me. I look stupid, but I'm really not.
It's just all what we used to do at our house when we lived together. They all have their own blankets, and there's an extra one that they use. My son wets the bed a lot.
Oh, hold it. So
Yeah.
what you're telling me is you sent 3 blankets, 1 for each of the kids, and then an extra.
Yes, because my son wets the bed a lot, so he needs an extra one.
You gotta be kidding me. Is that your story?
That's what
You're gonna tell me.
I don't know what else to tell you. I wasn't to my wife.
Well, the truth would be okay.
You better change it, man, because he don't like it.
That's all I have.
Why'd you send? I'm gonna give you another shot. Why'd you send 4 blankets?
That's what I have because that's what we do at home. That's what we did before. That's how I know what she's done because she's told me. Because my son's extra blanket is actually on the bed at my house right now.
You already sent the
Like
corporal
she
behind
made
him.
the bed when she left, and it's still there.
Okay, what about driving past sporting events that she's at?
It's my understanding, but I'll let him explain it.
No, go ahead, Counselor.
He was driving his work truck from work to a auto parts store in the same city and then drove back to work right after that. So I don't think he stopped or drove by slow. I think he just happened to be, and I don't think he even knew. He told me earlier today he didn't know. He knew the kids had practice, but he thought they were not at practice.
How convenient.
Just so I'm clear, you addressed the package to the alleged victim in this case, have 3 kids, so you know that there are 4 people that are in that house. You sent 4 blankets, but are telling me they were all for your kids. I miss anything? Counsel, do you want a hearing on this? As to a bond violation?
I I guess maybe, do you know were the two of the blankets the same, or? If you know, I don't know if you know or not. I don't know.
I don't, personally, it doesn't make a difference to me. There's 4 blankets, 3 pillows, 4 people in the house. Package is addressed to the victim. That doesn't make a difference to me.
Nope.
Judge, I think we don't need to have a hearing. He could-
Okay,
could
let me
prosecute.
ask you this, because I'm about to revoke his bond. So, do you want a hearing on this, counsel?
Yes.
I figured as much. All right. I'll leave the preliminary exam date. I'll set a hearing. On his bond violation. Can everybody be ready next week? Might be appropriate we do it on Halloween.
Judge, I can't do it on the 31st. Unless we do it, or I guess I could do it right at 1.
Right at 1, yeah. You don't know how my days work.
Oh, I know.
I can, well, we normally set it at 3, but I don't know if that's going to cut later, causes you a problem.
Yes.
So,
I said something at 10 and 3. So I was like trying to.
there's no way for me to predict what that docket entirely will look like. What about the 7th?
I'm in an assault with intent to murder trial that should be ending at that time. So I think we could schedule it that day. I should be done.
All right. I'll set a hearing on his bond for November 7th, 2024 at 3 p.m. I'll still leave the exam date in place. All right.
Thank you, Judge. So it'll be here at 3 p.m.?
3 p.m.
Thank you.
All right. On that date, at this time, given what the court has heard, defendant's bond at this time is revoked, defendant's remanded.
Judge, can he have some sort of cash bond with maybe a GPS tether just to allow him to continue working? He was living at his job until recently. He had to move when he moved back in the house.
Revoked his bond.
I know.
Okay. No, I understand what you're asking, and I'm going to deny that request at this time.
Okay.
All right.
And then the hammer falls. The bond hearing is set, but the judge doesn't wait. He revokes the defendant's bond immediately. The defense pleads for leniency, suggesting GPS monitoring or cash bond, but the judge denies it coldly. The case closes with a sobering reminder of how fast decisions can turn when court orders are ignored. The narrator wraps it up with insight and reflection on justice and consequence. It's a tough ending, but a powerful one. All right, guys, that's the end of today's courtroom breakdown. If you enjoyed this analysis, make sure to like the video, subscribe to the channel, and we'll see you in the next one.